Okay. Well, we are going to get started, and a few people will most likely be joining us along the way. I'd like to welcome everybody to the May installment of the Hospitality Webinar Series. My name is Jeff Venza. I'm your host today. We are recording this webinar, and so that I ask that everybody please mute their phones at this time. If you have a colleague or somebody that could not make it today and would like to view the webinar at a later date, they'll be able to access the recording. They'll be able to do this actually at venzagroup.com. That's V as in Victor, E-N-Z-A, group.com. At this time, I'd like to introduce our moderator, Magnolia Hotels Vice President of Technology, Jeffrey Parker.
Hi, thanks guys, and again I apologize for my tardiness. Our hotel Wi-Fi network just went down and I had to jump on my hotspot to get connected to you guys. So I am here now and I'm excited to be part of moderating this panel. Scott, I don't have your contact information here, so would you like to, it'll be one more second, do you want to introduce yourself?
Sure, I'll be happy to do that. My name is Scott Warner. I'm an attorney out in Seattle, Washington at Garvey Schubert Bear. I work in the technology and intellectual property area and work in privacy and data protection for a variety of clients, including hotels and vendors to hotels. And my email, if you need to reach me, is sgwarner@gsblaw.com.
Terrific. Please, I need one more second to get this webinar downloaded, and I will be 100% all yours.
This is Marion with Hospitality Evolution Resources. Both of these gentlemen are active contributors to the privacy debate and data protection discussions in a variety of industry and trade publications. We were delighted to have you both join us in today's webinar as our moderator and interrogee. So we'd like to say thank you again for joining.
Happy to do it. Thank you for inviting me.
Yeah, I'm very happy to be here as well. So we've gone through the introductions here. We had some questions that were submitted in advance, and we went ahead and put those in the presentation. As I know, some questions will also come in later, but I wanted to start with the first question. Is there a legal definition of reasonable care in the data handling realm, or failing to exercise reasonable care, and how will this impact class action lawsuit that might result from a data breach?
Oh, well, before we get started with that, just let me just say the information, obviously, discussion here is, I have to do this, so I apologize, is for informational purposes and is of a general nature and shouldn't be regarded as legal advice. For legal advice tailored to your individual circumstances, you should consult your own attorney. So with that out of the way, well, this is an interesting question, and it's a difficult one. So a great way to get started. So reasonable care is typically defined as the degree of care that an ordinarily prudent and rational person would use under the circumstances. So if you're looking for specific guidance, that doesn't give you a lot. And there's a similar standard that applies in the sort of privacy world. But before we get to that, there are 9 or so federal privacy statutes. There are 14 plus privacy regulations. Most states have laws governing some aspect of data privacy, and there are 46 states have enacted data breach laws. The foundation of all of those laws and regulations is reasonableness. Very few of them give specifics as to what needs to be done, in large part because the technology and the expectations of the recipients or the participants are in flux. In California, for example, AB 1950 provides that every business that owns or licenses personal information about a California resident needs to implement and maintain reasonable security procedures and practices appropriate to the nature of the information. So like the definition I gave you a little bit earlier, not a lot of guidance there. Doesn't indicate what is unreasonable. Similarly, on the federal side, where most people in the hospitality industry would be covered as well, the FTC, which is the agency that's most active in enforcing privacy, applies a reasonable standard in determining whether practices are unfair or deceptive. The FTC generally looks to what's reasonable and appropriate in light of the sensitivity and volume of the information that the entity holds. It looks at the size and complexity of the data operations and the cost of available tools to improve security and reduce vulnerability for breach. So again, no clear requirements, no clear definition of what reasonable care is. So what's that mean to people in the industry? Well, it means that you're really looking at what some call sort of a developing common law around what's required and what is reasonable. And for that, you need to look to the 50-plus settlements that the FTC has entered into with various companies on the subject of data privacy and security. And so those are mostly examples. So what do you need to do in order to be reasonable? You need to do what you say you're going to do in your privacy policy. You need to meet industry standards. So if your industry has adopted best practices, those are things you need to make sure you are complying with. You need to monitor and update what you're doing, because in this field, I think, as we all know, it's in flux. There's nothing that's static. In fact, the only thing that's that we can really rely on is that things are changing, and they've been changing since the FIPS were announced in the 1970s. Today, you're probably more likely to be covered by a regulation or a duty, and the cost of compliance and the cost of failing to comply is higher. So you need to monitor and update what you're doing on a regular basis. Those are general sort of guidance on what is reasonable, but in terms of looking at the settlements that the FTC has entered into, you can derive some additional guidance. So, for example, it's been held to be unreasonable not to have firewalls in place. It's been unreasonable to have procedures that don't require both people who participate on the site and employees to change their passwords. It's unreasonable not to install updates and patches to your operating system that deal with security, for example. It's unreasonable not to require something more than a 4-character password. In other words, having a complex password. It's not reasonable to store, for example, credit card information in clear, readable text that could be available to a hacker. It's not reasonable if you don't monitor and filter outbound traffic for disclosure of personally identifiable information. It's not reasonable not to limit third parties to access to your system. So in sum, as to reasonableness, is there a specific definition? No. Is there a developing definition? Yes. And the best course here is to monitor the standards that are promulgated or best practices by the industry, and to monitor your own behavior on an ongoing basis, and to pore through and carefully look at the results of these settlements, I think, that the FTC's entered into as a way of determining what is unreasonable. And that way you can inform sort of what your behavior ought to be. To the second half of this question, how will this impact a class action lawsuit? Let me scroll over here. That results from a data breach. So pretty obviously, given that there are no specific requirements in most cases that you must meet, there's a high likelihood that after a large data breach, there will be lawsuits that will include a large class. And the reason for that is, I think, pretty straightforward. If you can't point to a specific thing that you've complied with as a defense, then it sort of invites folks to sort of pick at whatever you've done. Whether it's going to be successful or not, that is the class action, really is open to question. Most of the cases, at least that I've seen, the class actions, the individuals participating in the class have not been too successful, and there's a couple of reasons for that. First, plaintiffs, in order to prevail, need to have standing. That means they must demonstrate that they have an interest of both concrete and actual or imminent harm. And in most data breaches, it's pretty difficult to identify which specific individual's data was obtained by the hacker, for example. And so in many cases, the plaintiffs don't get past a dismissal, don't get to trial because the action is dismissed early on, either because the plaintiff doesn't have standing, can't identify that their information was actually compromised, or secondly, that they actually suffered damages as the result of the data breach. And the reason for that is there are remedial steps that the controller of the information is required to take to mitigate those damages, and so quite often courts dismiss those claims. That's not to say that'll always happen, but it's been sort of the standard to date. So I hope that answers that question.
I think you covered all the bases on that. That's terrific. We'll move on to the next question here. We hope. In the event of a security breach, what are the hotel's obligations regarding informing their customers, employees, law enforcement, and/or government agencies? Do these obligations change based on the size of the breach, state or local or foreign government impact, and whether personally identifiable information is breached or only credit card information?
Okay. Well, so with take the U.S. First, I guess. So the United States is a little bit different than other countries, in a variety of respects, I guess. It's a rather broad statement. So the data breach notification requirements in the U.S. Are generally limited to obligations under state law. There are some exceptions to that. HIPAA, for example, for healthcare information, personally identifiable information, protected health information, I'm sorry. But in most cases, the issue of data breach and what an entity's obligations are dictated by the law, state law. There is, under discussion in Congress, proposals to have a national standard for this type of thing, in part because it would be nice to have, some harmony as to what the obligations are. But currently, 47 states have data breach notification laws, and they have different provisions, and so it's important to be familiar with those. Now, while they do have different requirements, they also have some commonalities. So most of them include a definition of what constitutes personal information, so what triggers a reporting requirement. They usually include a definition of what entities the law covers. So, are you in fact subject to the statute? They include a definition of what constitutes a security breach, the type of harm that's necessary to trigger the notification requirements, whom and when to notify the data subject, what to include in the notification, how to notify, and exceptions that might apply. So most of the statutes have those requirements. So there is some consistency. 20 states, so not all of the 47, 20 states require that entities notify the Attorney General or a state agency in the event of a breach. 27 states require entities, again, not all of them, require entities to notify nationwide credit card reporting agencies. But all of the states require the entities notify the state residents whose personal information has potentially been compromised. And in some states, Texas, notably, requires you to notify not only Texas residents, but the residents of states that don't have data breach statutes. So that would include Alabama, South Dakota, New Mexico, I think. So bottom line is there are rules. You need to comply with them. And so then the question is, what do you need to do? So as I said, they're not consistent across all of the 47 states. I'm getting some feedback.
That means
Yeah, I
someone
just heard that on too. It sounded like somebody got off the speakerphone.
Somebody just joined and needs to hit mute.
Okay, great. So, I'll take two good examples of sort of what is required in the event of a breach. Under the California statute, referred to as CalOPA, it requires that a business notify California residents whose unencrypted personal information has been acquired or is reasonably believed to have been acquired by an unauthorized person. And that applies regardless of how many individuals are affected. So if you're doing business in California or any place in the country and California, you have data from California residents and there's a suspected breach, you need to notify those residents. And if there's a potential that more than 500 California residents were included in a single breach, then you also need to submit a breach notification to the California Attorney General's office. Massachusetts doesn't really, which is another state with a very strict policy, doesn't distinguish between breaches affecting one Massachusetts resident and breaches affecting many. It requires written notice of a security breach as soon as possible, and the notice has to go to the Attorney General. It's got to go to the Director of Consumer Affairs, obviously the affected Massachusetts resident, and so that's the general sort of overview of what do you need to do in the event of a security breach. Now, if there are citizens of foreign countries involved, then you're going to be required to comply with, likely to comply with the laws of those foreign countries with respect to their data breach rules. The question for the company will be whether, not so much whether they're subject to the laws of those foreign countries, but whether those laws are enforceable as to the entity, and they may not be. Something to keep in mind, however, is that with the recent EU changes in data protection and privacy, you may be subject to and the law, those rules may be enforceable if, for example, the data that you've collected resides at a location that is subject to EU law. So, for example, if you're using the cloud and your data that you collected includes data with respect to an EU resident, and that data is in the cloud and stored on a server in Ireland, it may be that not only are you covered by EU law, but you are now subject to EU law. That is, it may be enforceable against you. So it's important to know sort of not only whose data you have, that is, what individuals and where they're from, but where that data is stored and accessible.
Okay, I'm going to go ahead and skip ahead to the next question. That's great information, Scott. I'm just going to try to get a couple more of these in if we can in our time allotment here.
Yep. Yeah, sorry I'm going on so long.
No, you're doing terrific. I think we covered a little bit about California online privacy laws in that last question, so I'm going to skip over here to the abroad question. Actually, I think you also just answered this pretty well. So we'll skip down to, is the hotel owner or hotel company financially liable for losses suffered by hotel guests when personal information is compromised via employee negligence? Does the hotel owner or company have to be found liable in a court of law for that?
So, you know, in general, companies act through their employees. So the short answer is if an employee commits an act or is engaged in some negligent behavior in the course of performing his or her duties for the company, then the company is going to be responsible. The company itself is an entity and it doesn't really act except through its employees. So the short answer is yes, there could be some exceptions to that. But switching back to our sort of the first question, what's reasonable, and what would be deceptive act or practice, for example. You can imagine if you have a privacy policy that says we protect your privacy, but you don't have policies in place to train employees, for example, about how to handle PII, then you're probably violating your own privacy policy, and so regardless of how your employee acts, you have a problem. If your so training is absolutely important, because not only is it required probably to meet your obligations in your privacy policy, but it's necessary in order to meet the reasonableness standard, knowing full well that the only way the company acts is through its employees. So I'm not sure if that answered that question. Let me
I think so. I think you covered that pretty well. That the responsibility, importance of training, and certainly the responsibility that falls on all companies, because employees are actors of theirs. I think you did a great job.
Correct.
Let's skip down. Following on from the prior question, if the business is found liable of the actions of their employees, can hoteliers be found liable for their data handling and storage policies, and employee training is determined to be out of date or lacking in depth? So taking that to the next level, training is important, but what is reasonable, I guess, again, coming back to it for training.
Exactly. And, you know, as I said at the beginning, you know, the FTC, when it looks at these things, typically looks at two things. You know, is there a deceptive act or practice? That is, does your privacy policy say something that you're not doing? And, of course, your privacy policy needs to meet the requirements of the state laws that you're required to comply with. So under the California statute, you need to include certain things in your privacy policy. We only touched on that a little bit. And number one, and number two, in order to be reasonable, you need to take certain steps as needed based on the nature of the information you've got, et cetera. And that would necessarily include making sure that employees are trained. So.
Okay, so we're right up against our time limit there. Jeff, I think I'm going to hand it back to you to go ahead and close out the session. Is that all right?
That sounds good. What I'd like to do is thank everybody that joined us today. I would like to take another 5 to 10 minutes and ask a couple more questions and answers so that we have that recording for everybody to come back to. And so if you have to drop off, then thanks for joining us. And you can visit the recording starting next week. And so we'll just continue with a couple more questions just to make sure we get those in there. And thanks for joining.
And Jeff, may I please add that there were so many people who sent questions in preparation for this because they wanted to make sure their questions got answered. And some of those that have called in and joined may have not had a chance to submit a question. We will be doing a follow-up to this so we'd like to encourage you to go ahead and submit your question that you would have liked to ask today if we had a little more time. And that would be emailable to us at Marion, M-A-R-I-O-N, at her-consulting.com or to jeff.venza@venzagroup.com. And we will see about getting additional answers out.
Okay,
Perfect.
great.
Well, it looks like we have another super question for you, Scott, and we're going to close it out. So the question is, there's a growing preference to outsourcing storage and handling of guest information from the moment the booking is made to the follow-up stint as a way to mitigate risk. Today, there are even companies offering virtual CIO services and security guidance and management to help hoteliers rest easy. Some pointers on how you cover yourself legally when signing a contract with a company or service like this.
Sure. So, at the end of the day, the data, the data controller is really the entity that's responsible, and that would be in the example that you've given, the hotel, even though the data processor may be a third party engaged by the hotel to process that data. So I mean that sort of indicates what your interests are. What you really want to do, I mean, because you want a back-to-back arrangement, right? If the hotel is subject to obligations, whether it's under state law or federal law or international law because it's doing business in Canada or the EU or Australia, all of which have different data requirements, then it wants to be, then that entity wants to be sure that whatever its obligations are mirrored in its agreements with the data processor that it engages, or the cloud provider, for example, that it engages. That's why, for example, you see entities that collect EPHI, personal health information, and do cloud storage require that the cloud provider have a business associate agreement with them so that there is some back-to-back protection. So the kinds of things that you want to have in there are, and the kinds of due diligence you'd want to do are the same that you would do for a lot of the other services. You'd want to make sure that the, for example, the vendor's reputation with regard to the collection and data use is a good. They have a good reputation, that they haven't been subject to prior problems. You want to make sure that the vendor has a good financial situation and adequate insurance. And these are all things that you might put in a contract, for example. You'd want to know whether the vendor has sufficient security controls in place to ensure that the data is not lost or stolen. And you'd want to get reps and warranties with respect to that. And there are standards, international and, again, industry standards you'd want to get those vendors to commit to. So, for example, if they're handling credit card information, you'd want to make sure that they're handling the credit card information in a manner that would make sure that you, the hotel, are going to be PCI compliant. It's not going to cause you a problem. you'd want to make sure that to examine the point of transfer between you and the vendor is protected from potential security vulnerability. So those are the kinds of things you'd want. Things that you might want in your contract. Certainly you'd want a confidentiality agreement. You'd want some understanding of who actually controls or quote-unquote owns the data that they've got and how you might get it back in the event and get access to it in the event the arrangement changes in the future. You'd want to specify how the data is going to be used and for what purpose, and so that, again, sort of back to the back-to-back sort of idea that, you know, if you're limited in the way the data can be used, you want to make sure that your data processor has the same limitations. You'd want to make sure that the contractor has, if they're going to have subcontractors, all of their subcontractors are subject to the same sort of terms. You'd want to include a requirement that there be prompt notification in the event of a data breach. You'd want to have indemnities and warranties, obviously, with respect to not only notice, but providing assistance to you in compliance with your obligations to meet your, to comply with the data breach laws to which you're subject. Very often, if you get a notice of a data breach, you then need to take steps in order to put people, the data subjects on notice, and the data controller will have access to that information. You want to make sure that they're participating with you in that process. And so you'd want to get them to agree to provide you with assistance and notice. And then you'd want to make sure that they have the necessary security controls in place. For example, are they encrypting the data when they're sending it back and forth to you? So those are some of the things that you'd want to have in place if you're doing business with a contractor, whether they're in the United States or outside the U.S. And as I said, sort of alluded to earlier, it is important to understand where your data is being stored, because to the extent it's available or accessible in another country, you may very well be subject to the laws and regulations of that country, and those rules may be enforceable against you because you're deemed to be present in that location. Does that help?
Yeah, I think that was a big help. I think that, like the other people, like myself, I'm sure the other people that have listened onto this are probably now all scared, trying to figure out how to wrap their heads around all the different laws and all the things we need to extend our contracts with, and certainly how to reinforce our training and make sure we're living up to our own standards. I think that terrific information, absolutely. I think that you covered a lot of bases and a lot of in-depth thought. I know that I personally will be downloading this again because I couldn't write my notes quick enough, as what you were saying, to make sure that I've got that information. I've got a couple slides here on the two of us, if you guys want real quick. Anybody's more than welcome to shoot me an email if you'd like to. I'd love to talk to people about this. I love to deal with what's going on in this realm. And then here certainly is Scott's information.
And I'm as well happy to, if you have questions, happy to follow up and provide some additional guidance on these items. So it's a very interesting topic, and you know, for someone who's been involved in sort of looking at this issue for a long time, for me it's been very interesting to see what has been sort of started off as a very slow wave for a long time, since the 1970s, and you know, going back to the Brandeis and articles on the right to be left alone, a very slow progress, and in the last 15 years or so, a lot of activity, with the result being that, you know, as I said earlier, more rules, more likely to be subject to them, higher risk for noncompliance, and in fact, I think, and higher cost, and I think probably a bigger need for business reasons to pay attention to this, because I think consumers are starting to pay more attention to it as well.
Terrific. Well, thank you very much, and thanks everybody for putting this together, and certainly everybody who is in our audience. Jeff, I'm going to go ahead and pass it back up to you to close it out.
Okay, sounds good. Yeah, Jeffrey and Scott, we just want to say thank you for your time, and thank you everybody for joining, and we'll see you at the next webinar series next month. Thank you.
Thank you.
Bye.
Bye-bye.